Good afternoon, everybody, and a very, very warm welcome to today's HR Advice webinar, Preventing Sexual Harassment, a New Legal Duty. And let's introduce ourselves as well. So my name's Alice. I work here at Sage in the Newcastle headquarters, and I'm a learning facilitator specialising in webinars. So you might have seen me if you've attended any of the Sage 50 payroll webinars recently. I am also joined today by some special guests. I've got Advisor Plus HR Technical Consultant Sarah Kerr and Senior HR Advisor Melissa New to share their expertise on the upcoming legislation changes and just to get into the practicalities on what you can be doing to prepare for these changes. So I'll let you guys introduce yourselves.
Great, thanks Alice. So yeah, my name's Sarah. I've worked in HR for the last 10 years. Prior to this, I've worked as a solicitor dealing with litigation and employment disputes. I've worked within several sectors, including healthcare, insurance, retail, banking and facilities management. My role at Advisor Plus involves supporting the advisory team with complex and high-risk cases and focusing on upskilling and training.
And my name's Melissa. I have 6 years experience in HR. I currently have my level 5 CIPD certificate, and my role in Advisor Plus is a senior HR advisor. So that involves providing advice on the advice line to managers around their employee relations queries, including topics such as the one we're going to cover today, but also the likes of discipline, grievance, flexible working, etc.
Perfect, thank you both of you. And we will have a look at what we're going to cover in the session as well. So a bit of the contents. So we're going to be going over the current sexual harassment legal position and what exactly is changing, the new financial consequences and what this means for your business, and also what proactive steps you can take now ahead of the incoming legislation. So what changes you can make now. Just a reminder, you can access the slides that we've used throughout the webinar by downloading those handouts, and we will share the webinar recording a little bit later this afternoon as well, so you can watch that back as many times as you need and get all of these expert opinions and advice again. So yeah, without further ado, let's get going. So we'll begin with you, Sarah. Can you give us a bit of an overview of what the legislation is? And can you give us your thoughts on why this legislation is changing and why this is important as well?
Absolutely. So on the 26th of October, there's an amendment coming through to the Equality Act, which you might have heard referred to as the Worker Protection Amendment Bill. This marks a significant change to the current law on employers' obligations to protect employees from sexual harassment and places a new duty on employers to take reasonable steps to prevent sexual harassment. It's really extremely unfortunate that sexual harassment in the workplace is so common. However, it's also really reassuring that it's recognised as an issue that impacts employees across all kinds of workplaces. We know that around 30% of employees have experienced at least one instance of sexual harassment at work just in the last 12 months. Add to that, almost half of all sexual harassment incidents go unreported. So it's really easy to see why the legislation we're discussing today is being introduced by the government. The idea behind the new legislation, which includes strict penalties for breaching the new duty, is that every employer understands their responsibility to protect their employees from sexual harassment and make it clear to all that sexual harassment in the workplace is unacceptable, no matter how big or small.
Thank you, Sarah. And Melissa as well. So not everyone will know what the kind of legal definition of sexual harassment is. Would you be able to take us through that first of all?
Of course, yes. So the legal definition of sexual harassment can be described as unwanted conduct of a sexual nature which violates someone's dignity or creates an environment that is intimidating, hostile, degrading, humiliating, or offensive to them. If the behaviour has one of the above effects, even if it was not intended, it can still be considered as sexual harassment. So some examples of sexual harassment could include, but are not limited to, unwelcome sexual advances, touching, sexual assault, sexual jokes, asking about someone's sex life, or sending emails with material of a sexual nature. Hybrid and remote working is really reshaping our future in the working world currently. And I think it's important for businesses to understand that sexual harassment can still take place remotely, such as in the form of texting or emails, etc. So that's something to consider. It is important to note that harassment is judged itself from the employee's perspective and how the behaviour made them feel. What one worker or even the majority of workers might see as harmless or banter, another may find it unacceptable. And as such, it's really important to understand that conduct can amount to harassment or sexual harassment, even if it's not how it was intended.
Thank you, Melissa. And Sarah as well, can you give us the headlines of what the current position is in regards to the legislation, and then what exactly the new duty is going to change as well?
Absolutely. So currently employers are liable for their own acts of harassment and their employees, unless they can show that they took all reasonable steps to prevent harassment or discrimination. However, from the 26th of October this year, employers will be required to demonstrate or evidence that they are complying with the new duty to proactively prevent sexual harassment in their workplaces by taking reasonable steps to prevent it. Failure to do so will bring the possibility of some new significant consequences. Just to note, the Act protects those people who are in your business's employment, which is quite a wide definition. It will cover employees, but also contractors, apprentices, and even job applicants. In addition, the act of sexual harassment can be committed not only by other workers or employees, but by third parties such as customers. As such, it's really important that you take a wide view on this issue and protect your people from these situations in the workplace.
Thank you. And you mentioned there that there are some significant consequences coming with this new legislation. So can you tell us a little bit about what this will look like?
Well, that's a great question. We've already seen tribunal cases published in the past 12 months with significant compensation awards being made for sexual harassment claims. Compensation for sexual harassment is uncapped. So understanding the additional consequences to the new duty is really important. The new duty will not bring a separate new claim for employees to make. Instead, it will increase the existing tribunal awards on what they look like for sexual harassment cases. And that's because if an employee successfully brings a harassment claim, the tribunal will then consider if an employer breached their duty. If it's found that they have, the compensation for the employee will then potentially be increased by up to 25%. Translating that into real figures, there was recently one of the largest sexual discrimination awards against a city company to date, following an employee being subjected to lewd comments, including, "I bet you like to be on top in bed," and being told to take a more submissive role. This saw the employee awarded £1.3 million in compensation for her claims. Now, if that claim had reached the tribunal after October of this year, the tribunal would have increased the compensation by up to 25%, which would have seen the employer paying out a further £325,000 in compensation, which is a really big increase.
Absolutely, Melissa. And another example is a recent case against a major food retailer where a teenage employee was subject to unwanted physical contact, included having her bottom slapped and her thighs and waist touched, along with inappropriate comments being made by her colleagues, such as their desire to have sex with her. When she sought to raise these concerns, she was told to take it as a compliment. She was successful in her claim for harassment on the grounds of sex, along with other claims, and awarded £50,000, £22,000 of which was due to injury to feelings. If this claim had landed after October of this year, this award could have been uplifted to £62,500. If we remember that 30% of employees have experienced sexual harassment in the last 12 months, if all of these individuals successfully pursued an employment tribunal claim, the financial implications for the business could be immense. So in addition to this, The Equality and Human Rights Commission will also have the power to take enforcement action against employers who don't do enough to prevent sexual harassment. And that could include things like conducting their own investigations and entering into binding agreements with the employer to ensure that they address the issue. We've seen examples of this being done previously with large businesses like McDonald's and IKEA. However, they could also go even further and take regulatory actions against businesses.
Thank you, Sarah, and Melissa as well. There are some really interesting examples actually, and thank you for all of the information with those as well. So with that being said, we are looking at some quite significant consequences for not being able to demonstrate that you've taken the reasonable steps to prevent sexual harassment in the workplace. What steps can businesses take to prepare for these upcoming changes in October?
Well, the consequences that arise for breaching the new duty mean it's absolutely worth taking proactive steps now so that you're ready for the new legislation to take effect at the end of this month. We looked at some stats and data that we analysed across our client base here at Advisor Plus and found that 1 in 7 of our grievances raised are sexual harassment related. And this has been increasing year on year. So this is roughly 15%, not factoring in the fact that almost half of sexual harassment cases go completely unreported. The risk really is huge. The new duty is also bringing much more awareness to the subject, and so we may see more victims coming forward. So there's lots we can do, and we can all be doing in advance of October to make sure your business is compliant. One of the first steps you can take is to update your current anti-harassment policy or handbook to include a specific section on sexual harassment. If you can, I would recommend that you create a completely separate policy specifically for sexual harassment so that employees know exactly what to consider if they do have concerns. I recommend that it's located in a central place for all employees to access. And I'd recommend that it also ensures that the information that the employees need is accessible to them should they need to refer to it in the future. When implementing the policy, I would recommend that the policy is shared with all employees. A great tip is to include a statement for all employees to complete, confirming that they've received, read and understand the policy. This means that they know from the very start what the policy prohibits and what the consequences of violating it are. With all policies, you should make sure that this is reviewed regularly to ensure it remains up to date and that the employees are also periodically reminded of the importance of this policy. Within the policy, there should be a clear legal definition of sexual harassment, so almost identical to what we've mentioned earlier in this webinar, and it should be made clear that such behaviour is unacceptable. The policy should outline a clear reporting procedure that's easy for employees to understand and use when raising their concerns. The policy should assure employees that their concerns will be handled confidently and that they will be protected from any retaliation for raising their concerns. The policy should encourage employees to come forward when they see behaviour which is unacceptable. Ensuring that employees know they will be protected after raising a concern is particularly important, as it's something that a tribunal will look upon when reviewing what reasonable steps have been taken by a business. To make sure that employees know that they can feel safe in their working environment. You might also want to consider putting up signs and notices to remind everyone of your harassment policy and that inappropriate behaviour will not be tolerated.
Absolutely. However, having just a policy alone isn't enough to protect you from any wrongdoing findings at a potential tribunal. A tribunal would also look at how you have dealt with any complaints that do come in. For example, in the retail case that we mentioned earlier, although the employer had an anti-harassment policy, they were criticised by the tribunal for allowing a culture of apathy towards sexual harassment to develop and for not properly investigating employees' concerns. So secondly, we would recommend that you ensure that any complaints received are taken seriously and are investigated quickly and thoroughly. It's important that you ensure that all complaints are investigated appropriately. even if they are historic. As an employer, you should be demonstrating a zero tolerance approach to sexual harassment in the workplace. So in order to protect the culture, morale and employee confidence, it's imperative that you look into these and take it seriously. Allegations of sexual harassment can have a massive impact on all those involved, whether or not those allegations are found to be upheld or not. Therefore, investigations must be conducted as sensitively as possible, and it's important that you provide support to both parties. We would advise that when being informed of an allegation of harassment, that a discussion is held with the parties involved as to what their needs are, and specifically what they would like to do in terms of the workplace in the period of time immediately following the allegation being raised, to understand their views and what their desired outcome of the investigation is. Remember that the key to a good investigation is maintaining discretion and confidentiality throughout. You don't want any gossip in the workplace impacting the complainant negatively, as this will prevent them from coming forward with more detailed information, or worse, prevent others from coming forward with their own complaints in the future, as they don't feel it will be dealt with seriously. During the investigation process, employers should consider and bear in mind the respect of both the employee who has raised the complaint and the accused, and consider whether either party needs to take time off work, whether they can be separated from one another by changing their working hours or location, or whether the accused needs to be suspended. It is important, however, that the complainant is not made to feel punished or isolated from the workplace for raising a concern. It's equally important that the accused is assured that any arrangements made, such as changing location or even suspension, is not a punitive measure. It's simply in place while the investigation is being completed to protect all parties and the investigation process. The investigation process itself would be similar to any other workplace investigation. However, there are some key pointers to consider when dealing with a sexual harassment investigation. So firstly, given how distressing this may be for all of the individuals involved, it's crucial that there are no delays in the process and that the facts are gathered as soon as reasonably practical. And any recommendations or actions required from that are taken at the earliest opportunity so that the parties involved can move forward. Another consideration is where you might want to conduct the interviews with these individuals. Can they be held somewhere more private and away from other employees? Again, trying to protect them from any unnecessary gossip in the workplace. Speaking of keeping it private, it's a really good idea to discuss this with all the parties and make sure that any information discussed within their meeting is to be kept strictly confidential and not shared with anyone else beyond that meeting. Ultimately, preparation is the key, and before starting the investigation, it's always a good idea to have a clear understanding of what the allegations are, and therefore what needs to be investigated, what facts need to be established, what evidence needs to be collated, and who needs to be spoken to. You should also consider who will be an appropriate investigation manager. You will need to be confident that they are able to be impartial and are unlikely to be influenced by the people involved. And you may also want to consider the gender of the investigation manager. Is that going to have an impact in the situation? There should also not be any conflict of interest or pre-existing relationship with either of the parties involved, and that manager should ideally be trained and experienced to be able to conduct an investigation of this nature. Ultimately, the investigation is a fact-finding exercise to find out the truth. So it's important that the investigation manager is able to keep an open mind and not assume blame, and they may need to be someone who will be respectful to all parties. You should also be mindful when appointing an investigation manager and what might happen with an investigation result, and if there's a requirement for any formal action. So there will also need to be someone independent to carry out further formal meetings, and perhaps even someone further who is independent to be able to attend any potential appeals.
Absolutely. Now, another proactive step that the business can do is to assess the risk to their business by carrying out a risk assessment specifically for sexual harassment. This will allow employers to identify risks and factors in the workplace and the extent to which this may increase the likelihood of an employee or others experiencing sexual harassment. Having a strong leadership commitment towards managing and controlling the risks of sexual harassment to eliminate or minimise the risk is key. I would recommend that you review the work that your employees undertake and what your workplace looks like to identify what factors could put people at risk. Once you've identified the factors, you can then assess the chances that the employee may be harmed by these factors. This could be measured as high or low risk. Then the third step to the risk assessment would be to identify what measures or controls you can put in place to prevent the possibility of sexual harassment.
Thank you. This is great from both of you. So on that, can you go through some examples of what risks might come up in a risk assessment and who might be at risk as well?
Yeah, absolutely. So obviously each business and their working environment is completely different, and therefore the risk assessment will need to be adapted to suit your particular business. But some examples, for example, one business at risk may be that they have a significant amount of remote working, which may mean that the sexual harassment takes place over messages, emails, or even on personal devices, which may be difficult for management to know about or monitor. A preventative measure for this can be to update your relevant policies, such as your social media policy, your electronic devices policy, to ensure the policy includes appropriate warnings against harassment and encourages staff to report incidents, even if these take place on personal devices. Another example of a risk factor may be that an employee works in events where they work with third parties such as customers, and alcohol is consumed at these events. And a preventative measure for this could be to ensure that any staff working alone or with the general public in high-risk situations have access to immediate report and support facilities. A third example of a risk factor could be that you employ employees who are not fluent in English and therefore may not completely understand the policy or how to confidently report the sexual harassment. One preventative measure for this could be to translate your key documents for them. As our workplaces are always evolving and no one workplace is the same, to help you identify these factors, you might want to actually discuss these with your employees to gain their thoughts on where the risks might lie. For example, research shows that workplace sexual harassment is more prevalent for younger women, disabled women, BME workers and LGBT community, migrant workers, and those in insecure forms of work such as zero-hour contracts and agency work. However, don't forget that sexual harassment can happen to anyone in the workplace, and not just from your employees, but also your customers, clients, and contractors. The key to success is to make sure that your preventative actions are people-centered, practical, adaptable, and designed to minimize harm to everyone.
Brilliant, thanks, Melissa. The final practical step that we're going to recommend to you today to take as a preventative measure is training. Obviously, ensuring that your employees understand the legal standard and the policy is important, but it's just as important to provide specific examples of what workplace harassment looks like in order to bring the learning to life. To be effective, training your employees is more than just telling them to just not to do it. To help with this, your training could include less obvious examples, as quite often this is where we see issues arise. I think people immediately think of just physical actions when they think of sexual harassment. That's very much not the case. A really good example of this is a recent case where a male chef successfully claimed sexual harassment after his male boss repeatedly made sexualized gestures and sang the Victoria Wood song Ballad of Barry and Frida at him and put specific emphasis on the repeated words, "Let's do it." This is perhaps less blatant than some of our earlier examples where someone has been physically touched inappropriately, but demonstrates that the definition of sexual harassment is wide and is based on the perceptions of the person who is subjected to the behaviour in question. Training should always advise employees of what to do if they experience it, linking back to your procedures and policy and how their complaints should be handled, so that your managers understand how to address concerns sensitively and confidentially. Specific manager training on how to role model acceptable behaviour, spotting inappropriate behaviour, and what to do if they receive a report of inappropriate conduct would also support employers to ensure that their zero tolerance policy for harassment is communicated from the top down. We've also had some recent case law which has given us further guidance on what the tribunal are looking for when considering if an employer has given effective training in this area. So when deciding whether the employer has taken reasonable steps, although in this case some training had been rolled out by the employer, the tribunal felt that the training wasn't meaningful and hadn't been repeated, therefore reducing the chances that this knowledge would be embedded in their employees' day-to-day actions. This particular company's training was criticised as stale, out of date and tick box, so some overall pretty scathing commentary. To try and combat this, it's a really good idea for employees to keep a record of who's received that training so that they can ensure that it's refreshed regularly with up-to-date content and then evidence, if they need to, that they have taken those reasonable steps. Ultimately, effective training isn't a one-off event and will enable employees to understand that there are serious consequences to their actions and that they have accountability for their own behaviour. Managers will have also more awareness of how to ensure control measures are in place to protect their teams, and employees will have more awareness of what to look out for if they witness or are subjected to any inappropriate behaviour, and that they know how to report it, safe in the knowledge that it will be handled discreetly and fairly. This should, all in all, empower individuals to act appropriately to create a more respectful and safe environment.
Thank you, Sarah. Fantastic advice. And again, thank you for sharing your thoughts with us today. It has been really useful insight. Now, following on from this, we have had a few questions through. So before we close off the session, I just thought we could tackle a couple of these together. So the first one that I've got highlighted here is the new legal duty comes into place on the 26th of October. What about reports of sexual harassment that took place prior to this date? Will compensation levels for these claims be uplifted as well?
Thanks, Alice. Yeah, that's a really good question. So our view is that the new duty, and more importantly, those financial consequences that come with it for non-compliance, will only apply to events which took place after the new duty has come into force, as that's when employers are going to be expected to comply with that duty. If it were to apply to events which took place, say, in February this year, for example, but the claim landed after October, it would feel disproportionate to hold the employer to that higher standard of the new legislation when this wasn't in force, or there wasn't an expectation of that when the sexual harassment occurred. Obviously, all that said, from a cultural and proactivity point of view, we think that showing that you started to take proactive, reasonable steps, like we've discussed today, well in advance of the 26th of this month, will show that you're taking that obligation seriously and are ultimately setting and confirming expectations amongst your employees and colleagues about what is and what isn't appropriate behaviour.
Great, thank you. The next one I've got as well, this one's for you, Melissa, is what do we do if the person who complains about sexual harassment then doesn't want to assist with the investigations? How can we make sure that their original concern is properly dealt with?
Okay. So we do see cases on our advice line where someone makes an initial report of harassment to their manager, but doesn't want to get anyone in trouble, doesn't want formal action to be taken, and just asks for the behaviour to stop. We know that this makes an investigation manager's position very difficult under the current legislation, and the new legislation makes it even harder, especially where someone's account of what might have happened is the only evidence available. Firstly, I would encourage the investigation manager to have a wellbeing conversation with the individual. At the heart of these concerns is an individual who's feeling uneasy. So make sure that they've got the support required in the workplace in terms of their working arrangements, and that they are aware of any wellbeing support that you as an employer can provide. Following this discussion, you should make them aware that you are concerned that the behaviour they've reported isn't appropriate, and that we want to make sure that all employees feel safe and secure when they come into the workplace, and that you have a duty of care to them to investigate the matter properly. You should discuss the confidentiality of the investigation process and encourage them to attend the investigation meeting where possible. If they still refuse this support, consider what other evidence might be available for you. So, for example, is there any CCTV of the incident? Were there any other witnesses present at the time? It's always really important that you as an employer can document as much evidence as you can to help you make sure that any allegations are dealt with fully and fairly.
Thank you, Melissa. I've got another one here as well. Someone else has said, you've given some really great advice today and lots for us to think about before the legislation comes into force at the end of the month. Once we've taken the steps that you've recommended, how can we make sure that we're proactively aware of what's going on when we can't watch everyone's behaviour all of the time?
Yeah, absolutely. That's a great question, Alice. And it's a worry that we hear echoed by our clients in respect of all elements of harassment and bullying, and not just sexual harassment. So probably say the first tip is to be aware of those warning signs that something's a concern, such as an increase in someone's sickness absence, a change in behaviour, a dip in someone's performance, or someone actively avoiding another colleague. You should also give your team every opportunity to raise issues with you, even when there's no warning signs per se. And that can include things like informal one-to-ones, making sure that you're having those return to work meetings with them after they've had a sickness absence, and also doing things like encouraging mentoring programs and staff networks so that your people feel able to have those difficult conversations in an environment that suits them. Also, if you've got a well-used intranet site for your employees, you might also want to consider introducing an online reporting system that allows them to make complaints either on a named or an anonymous basis. However, to protect everyone and to make sure that that system isn't used inappropriately or any vexatious complaints are raised as part of that, you would need to make it clear on that system and to the individuals using it what you as an employer might do with that information once it's been provided, such as commencing a disciplinary investigation.
Great, thank you for that. Really helpful answer. Last one I've got highlighted at the moment. So somebody said, once we've rolled out training, how do we make sure that everyone remembers this going forward and that our managers know what to do with these complaints alongside all of their day-to-day duties?
Well, I'd say, as with every policy that impacts your workplace, we would always recommend regular refresher sessions so that the importance of preventing harassment in the workplace doesn't fall off your employees' radar. You should always keep records of who has completed this training, when, and if you have one, when they last signed a declaration confirming they understood the policy and will act in accordance with it. Within your leadership team, you could also provide support and training to specific individuals and make them almost champions or guardians of the policy. This enables them to be a go-to for individuals who feel they may have been harassed or witnessed sexual harassment in the workplace. And then also support and signpost them with how to act in accordance with the policy.
Thank you, Melissa. There is another couple coming through actually. So Sarah, I've got one from you that's been asked, which is what is seen as a reasonable amount of time to pass before doing refresher training?
Yeah, and it is, there's no set amount of time that you can really put on that. It's not something where there's a formula or an equation that you can put on it. Probably say amongst a lot of businesses, a lot of clients, they'll tend to have kind of very formal settings for refresher training every 6 or 12 months. So you can put it in your calendar, diarise that, make sure everybody does that. However, I think kind of a key to kind of making sure that you're building on that culture that we discussed earlier on is, say, if you're having regular team meetings or regular huddles, make just quick pointers in there saying, just to remember, we've got these signs up in say the staff room, or these are out on the shop floor. Please do bear in mind those messages. When you've got 2 minutes and you're passing, have a read of those. And making sure that information's readily available, so that even in between those periods, people are consistently aware of their own obligations and duties.
Fantastic, thank you, Sarah. One more that I think we've got time for. So this is a question: can the investigating officer be involved in the disciplinary process if necessary after the outcome has been completed?
That's a good question. And you know, obviously preference and best practice in terms of what we would recommend is that there is a separate independent manager for each stage of the process. So that could be investigation stage, disciplinary stage, and then appeal stage. I do appreciate, however, that a lot of businesses have small companies, have small businesses, and don't necessarily have the management resources for that. So a recommendation would be, if that is the case and there is that low resource in you know, independent managers, that the same manager would carry out the investigation and the formal disciplinary hearing, but should certainly keep someone appropriate and independent for any potential appeals.
Perfect, thank you for that. And thank you to everyone for sending in your questions as well, and obviously for your answers too. I think that's all we're going to have time for in the session today. We've still got a couple of kind of further support and things to go through, but yeah, hope you found that valuable. If we haven't managed to answer your question today, don't worry, we will follow up with you personally after the session, so you will get that kind of answer that you need. So Sarah and Melissa, thank you for all of your expertise and guidance today. We really appreciate that. So a few things before we finish as well. If you would like help with anything that we've covered, please feel free to check out the Sage HR advice portal. We've just linked that on this slide. Or alternatively, if you are a professional or premium customer, please don't hesitate to call the advice line, and one of our consultants will happily provide any guidance on the topic that we've covered today. And then of course, don't forget you can download the handouts to have your own copy of all of the slides today as well. And just something else to be aware of as well. So Sage HR Advice, it's here to help you navigate and simplify those proposed changes that we've talked about today, as well as a whole variety of HR related topics. We've also got Sage HR, this will enable you to automate and simplify your HR tasks. So be sure to check these out via the link in the handout. Or if you are wanting more information, I am just going to launch a poll on your screen at the moment. That should just come up very shortly for you. So if you want to and you're happy to be contacted to know a little bit more information about Sage HR Advice or Sage HR, please just select yes on the poll and click submit. I'm just going to pass this on to my colleagues. They're going to be able to send you a follow-up email with some more information, and it's obviously up to you then. You can kind of evaluate whether or not it's something that you think you would benefit from. Both of these options are really fantastic, so I would recommend getting more information, but of course that's totally up to yourself. So fab. So those of you who did reply yes, do keep an eye on your inbox for more information coming through on Sage HR Advice and Sage HR. Now, in terms of webinars as well, we do run regular webinars every single week on Sage 50 Payroll and Sage 50 Accounts. This month on Sage 50 Payroll, we've got a whole pension series this month, so get yourself signed up for them at sage.co.uk/webinars. Me and Duncan will be taking you through a whole variety of topics, including pensions, the basics. So if you're fairly new to pensions or new to payroll even, just a bit of a kind of rundown of what the pensions, how that kind of works in the programme. We've also got the pension assessment, so if you're one of our pensions module users, we'll give you a bit more information on how to use it, when to run the assessment, and how to navigate around that as well. And things like pension calculations, if you want to know the kind of ins and outs, how your pension contributions are calculated, we'll be going through what different settings are used to get to those contributions, and kind of tips and advice throughout the sessions as well. And on a more HR related note as well, our next webinar in partnership with Advisor Plus is going to be on the 6th of November. So mark your calendars. The next one's going to be all about addressing performance issues in the first 2 years of employment. So as usual, lots more advice and guidance in that session with some really useful real life examples as well. And we do look forward to seeing you there. So with that being said, that does bring us to a close. And last thing from me, you will receive a short survey as you exit the webinar. If you do have just a minute to fill that out, we would all really appreciate that. We read every single comment, we look at every single score as well, and just really try to make these webinars the best that they can be. So thank you again from me, from Sarah and Melissa. And yeah, hopefully you enjoy the rest of your day. Hopefully we'll see you on another webinar very soon. So from all of us, it's goodbye for now.